Hi everybody. I really do hope you really enjoyed the session just now, which you just heard about 3 different stories on how things go spectacularly wrong in family businesses, but what can also go right. My name is Yue-En. I'm a EO spousal member. In fact, if you haven't guessed already or you don't know, I'm Teresa's spouse. I'm the managing director of my own law firm, Better Chambers LLC. I guess you can say that I'm an entrepreneur as well because I just started this business in May this year. And I specialize in what you call family law. So family law itself is not just about divorces. There is a lot more other areas which I also do. For example, family relationships, guardianship of children, estate issues, probate, succession planning, and of course my other specialized area, which is mental capacity law. Mental capacity law that is the law that governs court-appointed deputyships as well as the lasting power of attorneys. The worst thing that could happen to a business founder is if they wake up one day and realize that they can't make any more decisions. Why? Perhaps a stroke happened, a stroke that affected the brain, or it could be dementia. The dementia has gotten worse. So I'm sure that many of you here have heard the story of Yang-Ing and Madam Chung. So Yang-Ing was this tour guide from China who befriended old Madam Chung, who was 83 years old, and he convinced Madam Chung to make him her donee. A donee is a person who is appointed to manage your affairs. What happened here is she made what you call a LPA Form 1, which is a form that gives Yang-Ing great and extensive powers. She could do anything he wanted with regards to Madam Chung's assets and properties. So in the same way here, if you appoint someone as your donee under a lasting power attorney Form 1, theoretically that person can come in and do anything they want to your shares, anything they want to your business as well. So in a situation like this, have you ever thought what's going to happen to our business if we have a medical condition like that? I think much earlier on you heard Teresa share about her mother who was in a coma for 5 years. And I think that could be probably one of the worst things that could happen to any business. If you were running the business on your own and you're in a coma, do you trust that the people that you hired, your managers, would be the people who run it for you? But let's say if you are the sole owner and you are also your own board, what the strategic direction of the company? Who is going to be there in order to help your company to move along, make decisions, so that whatever you have labored upon, whatever you have built over all these years, will not have to artificially shut down just because you're not able to continue running the business. If, for example, let's say Teresa's businesses, she's not running it, and she appoints me as a donee, then I would come in and run her businesses. But then again, I'll ask myself, why would I want to run her business? I'm a lawyer. And as a lawyer, my specialty and my skill set is coming in to help people in their family and relationship problems. So with a lasting power attorney, you can actually have a more bespoke one called a lasting power attorney Form 2. We have many different aspects of our lives. For example, we might want someone to run our business for us. We might want to appoint our spouses to run our other aspects of our life for us. For example, I want someone who is very intimate knowledge of my business, let's say my partner in my law firm, to manage a law firm on my behalf. I will be making a lasting power attorney too to appoint my law firm partner to be my donee specifically to that. Maybe you have a couple of companies, but there's one specific one that you wish to preserve. All these things can be put inside your lasting power attorney Form 2. Specific restrictions to your donees who are selected on what not to do. What else you could do? You could do a statement of wishes, which is you can put out there what they can do or what they ought to do. You could express that perhaps I'm an investor. I only invest in eco-friendly investment products because I really believe in saving the world. No unauthorized animal testing should be part of this business investment that I make. This is something that I would give a guideline to my donees to follow. What is the process of doing it? Well, first of all, you start thinking, who do I want to represent my business interest to manage it if I lose capacity? After that, you think, is there any restrictions that I wish to place upon him? The third thing you think, is there any wishes that you wish to have him to carry out for you on your behalf? After that, you obviously speak to that person because the person has to sign your lasting power attorney Form 2, has to agree to be your donee, And once that is done, to approach a lawyer to draft it out in the lasting power attorney Form 2. The lasting power attorney of Form 2 can only be done by lawyers. Once that is done, the lawyer will then submit it to the Office of Public Guardian, who will vet through the form to see if there's any of the clauses inside that you put in is against public policy, which then they will strike it out. But if they don't do so, it will be officially registered on record. Once on record, this means that if the future, if any third party, maybe a bank or institution, wishes to recall it, they could see exactly what you have decided you wanted to do when you lose capacity, or recorded on LPA Form 2. So these are some ideas here to start you thinking. Is it really we are alive one day and tomorrow we are gone and we are dead? Or is it that there is this grey area of 10 years where in between that, as we lose our mental abilities, our mental connection, we end up in a state where it's neither life nor death, but it's specifically for this particular state that we want to plan for. They want to make sure that everything is placed. So, having talked about mental capacity itself, another issue that I'm sure you all heard a lot being shared tonight is that of family dynamics. You make a decision, that decision may not perhaps be respected or understood by your family members. In a situation like this, there is tension in the family. No one really agrees, and everyone perhaps may be shareholders sitting on the board as well. In a case like this, what is most important? Will it be the preservation of the relationship in the family, or is it someone having their way at the expense of everybody else? What we have here often is that when people can't agree, they start suing one another. And I think that's the most tragic thing that can happen to any family, because the very people who you expect to have your back are now the ones who you have to wonder, what are they plotting against you? So I think the perspective that I come from is, as a mediator, is that let's talk about peace. What is mediation? I'm not sure how many of you heard of mediation. So mediation is a process where a neutral third party, who is a facilitator, starts to help to bring about and facilitate conversations. What do I mean by facilitating conversations? So for example, there is an issue on the table. The board can't come to a decision because there are two opposing positions taken. They've been at it for months and they can't bridge the gap. There's an impasse. A mediator comes in. As a third party in this whole dispute, the mediator is neutral. They neither support either side. But what the mediator do is the mediator listens. He listens exactly to the concerns, to the interests. What is it that's motivating each side to stick to this position? Is it just because of what they say it is, or is there a much deeper underlying rationale? Perhaps it may be completely irrational. It may not even be the case that it's a business decision. It could be a relationship issue. Perhaps it's something that dates all the way back to childhood, like, my 姐姐 or 哥哥 never ever listened to me. It's like, I was always told what to do. I can't take this anymore. I felt I was never respected. Now, there's an issue that I, as a mediator, would want to hear mediation, because it helps us to understand deeper to what is basically at the root of it all that brings rise to our reactions and how we react to things. One very important thing to remember about mediation is this. If you go to a lawyer, they will ask him or her to be a mediator. Please don't ask him legal advice, because once he gives you legal advice, he or she is conflicted out. They can't act as your mediator. So how do you go about initiating the mediation process? Well, the first thing is to start by finding a mediator. When you find a mediator could be a lawyer, or it may not be he or she may not be a lawyer. If a lawyer, just remember not to ask the lawyer for legal advice, because that will conflict the lawyer from acting as a mediator, although the lawyer can still act as your lawyer in a mediation situation. After that, the mediator will be able to contact the party who you're having a conflict with to attend mediation. Mediation is voluntary. So if both parties not wish to attend mediation, mediation will not be able to carry on. In an event that has already been a lawsuit, you can always ask the other party to attend mediation at any point of time. Mediation could then lead to a resolution of the issue and for the lawsuit to be withdrawn. So this largely is the two ways which the mediation process commences. Mediation doesn't need to just take place between family members. It could take place between business partners. It could take place between friends. Anyone can go through mediation. But what mediation creates is this secure platform, one that is shrouded in confidentiality, one that is behind private doors. These days, mediation agreements can be transformed into court orders that are enforceable. So, why it is important? Not because you want to hold your family members to be bound to a court order, but let's say you need a court order to be enforced overseas or something to show authority of a different country that an agreement has been made. Why would I do mediation? That is because I want to preserve the relationships. Preserve the relationships between family members to ensure that when we walk away with a sense of peace, a sense of relationships that perhaps have been very icy and very rigid, once again touring. Touring so that once again there can be a new chapter in the family dynamics, one that will bring forth cooperation. Mediation is a tool for peace building and peacemaking. And I would imagine that that is always should or could be the solution adopted before even going into court, into litigation. So in summary, tonight we talk about two things. The first is about deputyships and lasting power attorneys, which are critical instruments that you will need to consider as part of your business continuity plan. For this particular area, I would really be thinking about who would I like to continue my business? Does my business have to end when I lose capacity? So for mediation, what we discuss about is family relationships. What do we wish to preserve this relationship? Do we have to go to court if we have a problem? Or can we find a neutral setting with a facilitator? Someone who will be able to come in to just moderate the discussion, and then after that get everyone to speak what's really on their heart. So something that we walk away tonight is this, is that when our conflicts or there are problems in family, or when medical issues overtake us, this doesn't mean that's the end of us, our businesses, or relationships. We can always do things to make it better so that legacies that we leave behind will be complete.